Imagine you are running down the street, and out of the side of your eye, you glance and see somebody's shoe. And on that shoe is it what looks like a check mark. From just that check mark, do you know which company made that shoe? Or imagine the shoe has 3 lines on it. Do you know, just from those 3 lines, who made that shoe? Those are perfect examples of trademarks. By seeing a mark, you know the source of the goods. That is a trademark. If it's a check mark, or what we call a swoosh, we know the shoes are from Nike. Now, it could be a counterfeit, but counterfeits are trademark infringement. The swoosh allows you to recognize a mark and then associate that mark with the source of that product. Likewise, if you see 3 lines, you know that's Adidas, which they call Adidas. Regardless, from that mark, you know the company that created those shoes. That right there is the essence of trademark. Now you might say, well, what about services, not products, services? Do you call it a trademark if it's a service? Well, technically we call it a service mark, but for all intents and purposes, you can just say trademark, because the law is the same whether the mark is associated with the source of a product or the source of a service. That right there is the general idea of trademarks. But let's go a level deeper. First, you might be wondering, do I need to register a trademark for it to be valid? No, you don't. Whenever you use a mark in association with your goods or services in a county, you acquire common law trademark rights in that county, assuming you're not infringing somebody else's mark or their mark is confusingly similar to yours. So in other words, let's say your mark is not a swoosh like Nike uses or 3 lines like Adidas uses. Let's say your mark is a name of a company. So let's use a little example. Let's say Kodak, and you have a camera company, and you made up this word and you call it Kodak. Let's assume Kodak doesn't exist anywhere else, then the word doesn't have meaning on its own. If you start using Kodak in association with your business selling camera gear or film or providing camera and film services, you have acquired a common law trademark, or you could say service mark for the services, in the county where you have business operations. Now you might say, well, that's great, but I'd love to have protection in all counties in the United States. I don't want to start growing county by county and then find out somebody else is using it somewhere else, so I can't. Well, that's where you can go and register a trademark. When you register a trademark, you get all sorts of rights. One of those rights is nationwide exclusive use of your mark with your goods or services. Now keep in mind, it only is by industry. The other thing is, one of the rights you get when you register your trademark is you get the right to file paperwork with Border Patrol. Border Patrol analyzes all of the goods being sent in through the border, and they will check to see if any counterfeit goods are coming in. So you might think to yourself, well, wait a second, if I can get trademark rights to a word and nobody else can use that, I should just go get a trademark registration in all the words for my industry. The law says you can't do that. That's an attempt to trademark generic terms. So let's talk about this for a second. And once we get done talking about what a trademark is and what can be protected, then we'll talk about what can you do to protect your marks and what can you do to avoid infringing other people's trademarks. Because at the end of the day, those are the real goals here. How do we protect what we have, and how do we avoid running into legal trouble by infringing other people's trademarks? So let's start out with what can be protected. Obviously, you can have symbols or logos or other sorts of marks that are uniquely yours and you regularly use to show, hey, this is a shoe from Nike or a shoe from Adidas or whatever your product is from your company. In addition to simple marks, you can use words. But let's talk about words, because on one end of the spectrum we have generic words, and on the other end of the spectrum we have words that you made up that actually don't exist. Those are called fanciful. Fanciful is, hey, you just made that up. That's not a real word. It will not exist in a dictionary. That's a word like Kodak or Xerox. Those are names somebody just made up. But that's the spectrum. And there are actually 5 categories on this spectrum. So on one end is generic, the other end is fanciful. But similar to generic is descriptive. A descriptive trademark is one where it describes what's happening there. So I'll give you an example. Plumber is generic. You can't prevent everybody from using the word plumber. You can't get a trademark in that. But let's say you decided to go after skills plumber. So essentially you're saying you have skills and you're a plumber. Now, can you prevent every other plumber from using those words? Or let's say, for example, your business name is Minneapolis Plumber. Can you use everyone else from using that? Well, that is a descriptive term. It's either descriptive because it's using a geographic identifier like Minneapolis, or it's using some other characteristic identifier like skills. Either way, it's describing it. And the general rule in trademark law is you cannot get a trademark registered for a descriptive mark. But there is an exception. If after 6 years you can demonstrate that the public generally perceives that phrase as associating with you because you have used it so predominantly, then you can acquire trademark registration rights in it. This is a rare exception, but there are times when companies have had a descriptive mark and they've used it so much that everybody kind of thinks of them. I'll give you an example. Best Buy. Best Buy is a company that sells technology and products to people. Well, a lot of people might say, hey, we're the Best Buy. We're the store where you can get the best buys. Come to us. You want the Best Buy? Come buy from us. But Best Buy has so predominantly used that phrase that it has acquired rights even though it is descriptive. So it's a rare exception. What's the takeaway here? Don't use generic or descriptive names for your business because you might not be able to stop anyone else from using them either. And you're going to especially have a hard time registering those sorts of trademarks. Now let's talk about the next category. We're talking about 5. We've already covered generic on one end, fanciful on the other. Then we covered descriptive marks. Those are ones that are describing the goods or services. What's the next one over? Suggestive. A suggestive trademark is one where a certain logical step is required. I'll give you a little example. Netflix. So if you think about it, Netflix is basically internet movies, or flicks is a synonym for movies, Net is a synonym for internet, and so it's essentially saying internet movies. Internet movies would be descriptive, but Netflix, especially as a single word, requires some logical step. It's suggesting what the meaning is, but it is not describing what it is. So it's a logical step removed from descriptive. So we have generic, descriptive, suggestive, and you can register trademarks and you can acquire trademark rights in a suggestive trademark. You might be thinking to yourself, our business name is not some made-up word. That would be fanciful. And our business name is not suggestive, related to the attributes of the product. It's another name. It's somewhere between. It's real English words, so it's not fanciful, but it's also not describing or suggestive of attributes of the product or services. It's somewhere in between. What are those called? Those are called arbitrary. Arbitrary trademarks. You can get trademark rights and protect arbitrary marks. In fact, most of the marks out there are arbitrary. One of the greatest examples of this is Apple computers. Now, does that mean nobody can ever use the word Apple? Like if you're a grocer and you want to have a sign that says Apple, 5 cents, above a box of apples, is that illegal? No, that's not trademark infringement because that sign is describing the fruit below it. But Apple Computers has acquired exclusive use rights in Apple associated with computers and various other technologies. And that keeps expanding because Apple has gone into music and gone into movies and gone into a number of other categories. So Apple has an arbitrary mark associated with computers and various other categories, but Apple can never get exclusive trademark rights to Apple as it relates to fruit because that's generic. So that gives you the spectrum and you can identify where is my business name on that spectrum? Or if you come up with brand names, you can be thinking about, hey, is the idea I have protectable under trademark law? Basically, if it's describing or generic, it's not protectable. And if it is a unique word like Netflix, if it's a word out of context like Apple, or if it's a totally made up word like Xerox, then you can protect that name or that mark. And specifically right now we're talking about words that are used in trademarks. But not every trademark is a word. It might include numbers. It might include some other graphic design elements. All right, let's talk about some examples. These are Band-Aids. Band-Aid is a brand of bandages. What that means is bandages is the category name that cannot be trademarked, but Band-Aid is the brand name that is trademarked. Now you might say, well, but this is a bandage, and that's short for it, and it's providing aid. Is that descriptive? The answer is no. That's more suggestive. That's a suggestive mark because it is suggesting what it does. Band-Aid suggests that it's a bandage providing first aid. So if you have another brand of bandages, can they use Band-Aid? No, they can't. They can use bandage, but they cannot use Band-Aid. So that's an example of when you are dominating an industry like Band-Aid is. You have your brand name, and then you need to state what the category is. This was a popular issue when Rollerblade produced a roller skate that had one line of rollers on it. Everybody just called those Rollerblade, and there was no category for it. It was roller skates on one end, and then you have this Rollerblade. Well, rollerblade was at risk of being used in a generic way because when other companies came out with a skate that just had a line of rollers in it, they would say another brand of rollerblade, or it's rollerblade, and they'd use it as a category name, and then they would say their brand. Well, rollerblade's attorneys smartly told them, you need to figure out what the category name is and start reinforcing rollerblade is the brand. And so they came up with the word inline skate. Inline skate is the category. And so rollerblade spent a lot of money in its early years differentiating between the brand rollerblade and the category name inline skate. So if you're new to a category and you define the category with your brand, it's important to make sure your brand is separate from a description for the category that your competitors can use. Otherwise, your brand becomes generic, and that means everybody can use it. Let's pause for a second and talk about the difference between copyright and trademark. Copyright is designed to protect the works of artists. It's the work that's being protected, and it can't be used or copied in any way without the artist's permission. Trademark is the law's protection of a mark associated with the source of a product or a service. Trademark law also then protects the public's right to associate a product or service with the mark. So for example, if you go to buy some shoes and they say Nike on them, you can expect a certain degree of quality from that shoe after you buy it. Nobody else is allowed under law to say Nike on the shoe except Nike. So by remembering that trademarks protect the public's right to associate a mark with the source of goods or services, and trademark protects the company's right to their reputation and making that connection between their goods and services. By understanding that, we understand the purpose of trademark is very different from the purpose of copyright, which is to protect artists and their actual work from being used or copied in a way they didn't consent to. Although copyright and trademark are both intellectual properties, their purposes are very different. They operate in very different ways, and they are totally separate as far as the body of laws that govern those areas. They just happen to be two types of intellectual property, but they're very different. Let's talk about trade dress. Sometimes there isn't a specific mark on the product, but the entire way the product looks has such a distinct look. In other words, it is dressed in such a way that you know exactly which company is the source of that product. I'll give you an example. If you saw a Coke bottle made by Coca-Cola Company and they have the swirls on it, even if it didn't say Coca-Cola on it, you may know as a consumer of soda drinks that that bottle represents Coca-Cola. Another example, if you buy fancy jewelry and you see a blue box, you associate that blue box with jewelry from Tiffany & Company. There are certain types of design that may not be a specific mark, but the entire product is dressed up in a way that you can associate that design with the source of the goods. That is what we call trade dress, and it's essentially a type of trademark. As a business owner, one of the big questions that you'll encounter is picking a unique name that nobody else is using. How do you do that? Well, first you can Google it to see if anyone else is using it. But if you're using a word, most likely somebody else is using that. So, when are you allowed to use it and when are you not? Well, let's say, for example, you want to do a brand name for Delta typewriters. Could you use that? Well, when you go to search Delta, You find out, oh yeah, there's Delta Airlines. One of the big United States airline brands is Delta. Does that mean you cannot use it for a typewriter company? What do you think? Well, I was going to fix a problem in one of our sinks. And when I looked at the brand of the sink, the faucet in particular, it was Delta. You can see here some of the parts that I've purchased for this repair. I'm going to be repairing a Delta faucet. So clearly in the faucet category, Delta can be used, and in the airline category, Delta can be used. Why is that? It's because as a general rule, you can use a word, even though it's trademarked, as long as you use it in a distinct enough industry or a different enough industry that consumers won't be confused. So what do you think? If a consumer goes to buy a little product here, do you think that they're going to wonder, hey, I wonder if that's made by Delta Airlines? No, it's a sink product. There's no likelihood that consumers will be confused by whether Delta Airlines made that product or some other company in the sink industry and faucet industry. That's the test. Are consumers likely to be confused? If the answer is no, they're not likely to be confused, then you can use the same name as another company, and it generally won't be considered trademark infringement. There are some exceptions to this. That's the big brands. For example, can you do a Mercedes computer? No, because the Mercedes brand is so big that you're not going to be able to use a big brand like that on any products. So the really big brands you can't use anywhere, because even though people may not confuse it as the same company, there's a separate legal doctrine that comes up called dilution. Dilution is where you're trying to ride the coattails of another company. You're hoping their vibe or their good reputation will somehow sprinkle some goodwill in the minds of the consumers onto your product. You're getting a free ride on their brand. So you can't call anything Mercedes without diluting their mark, and thus Mercedes would have a claim against you. Even though it's not technically trademark infringement, it would likely be trademark dilution. So we know what trademarks are. Now, what are your ways to protect them? If somebody else is using a similar mark that is causing confusion to your consumers, you probably have a trademark infringement case. Now, if you have registered your trademark, you have much stronger rights than if you have just relied on the common law trademark, because common law trademark doesn't acquire all of the benefits that trademark registration gives you. You can do a copyright registration without needing an attorney, but trademark registration generally requires an attorney. And the reason is there are a few pieces. First, the attorney is going to carefully define what it is you're protecting so that you don't accidentally get the wrong description, something that's too broad or too narrow or too limited or otherwise problematic under the law. Second, the attorney is going to identify the right categories and select the right classification so that your trademark gets the broadest protection possible. I've seen many times where individuals use online services, Rocket Matter, LegalZoom, etc. And unfortunately, those are just computer software services. You're specifically agreeing when you use those that you're not having an attorney represent you. There's been a lot of litigation about that. And the bottom line is those services are only allowed to exist as long as it is a software service using some sort of wizard where you're making the decisions. And unfortunately, a lot of times, and when it's too late, consumers and business owners have found out they did it wrong. You don't normally find out right away that it's a problem. You might, but often you find out later when somebody else starts using your mark, and all of a sudden you don't have the protections you thought you did. So I highly recommend you utilize a trademark attorney when you want to get a registered trademark for your name or your brand or your logo. One requirement under trademark law is you can't allow a person to infringe your trademark and just not do anything about it. In other words, the law requires that you monitor use of your mark and enforce your trademark rights. If you don't, the law basically says, we're not going to give you those rights if you don't at least enforce them. And you can't wait so long that some competitor who's using an infringing name starts building that brand. You need to take action relatively quickly to get them to stop. How do you do that? Step number one, make sure you are monitoring anybody else that's using your name out there. You can do that with Google Alerts. You can pay for a trademark service if you want, a trademark monitoring service, or you can manually go online and do Google searches to see, is anybody else using a confusingly similar name or mark as you in your industry? Then what do? You send them a cease and desist letter typically. Now, why not just send them a lawsuit? The reason is often you can just get them to stop if you send them a cease and desist letter. Usually that's sent by an attorney. It could be sent by you, but often the recipient of a letter that's not from an attorney may not take it as seriously. In other words, when a cease and desist letter comes from an attorney, usually the recipient takes it more seriously because they realize, first, the attorney is probably right about the law. Second, the person who hired the attorney is serious enough to spend some money to send a legitimate cease and desist letter to them. Now, you could go straight to court. You could sue, but generally you don't do that first because it's so much less expensive if you can resolve the issue by sending a cease and desist letter. Now, what happens if you ignore it and you allow some infringing business name to continue to operate and you don't do anything about it? Well, if you later try to sue them for trademark infringement, a court might say, no, you waited too long. There's no specific amount that's too long, but the general rule is you should act relatively quickly as soon as you learn that somebody else is infringing your trademark, and you should routinely be checking to make sure nobody else is using an infringing trademark. And when I say infringing trademark, what I really mean there is a name that's similar to yours, a logo that's similar to yours, or some other mark that's causing some confusion among your consumers or perhaps their consumers. You might wonder about DBAs, or assumed names. A DBA stands for doing business as. And are you allowed to use somebody else's trademark in your DBA or your assumed name? The answer is no. And by the way, DBAs go by multiple names, assumed names, fictitious names, etc. One of the mistakes that I've seen a number of business owners make is they either file a business name with their state business registration agency, like the Secretary of State or Department of Commerce. Just because you set up a business name or a DBA with your state doesn't mean you're allowed to use that name for trademark purposes. Trademark is an area of federal law, and most states will let you pick any name you want as long as nobody else has that exact name in your state registered. Let's say there's a business titled Mercedes Auto. I could probably, in my state, register a business name with Mercedes Automobiles, and the state wouldn't do anything about it. Or I could do Mercedes Electric Vehicles. My state is not going to do anything about it. That is a trademark infringement clearly. But when you register a business name or a DBA or a corporation or an LLC with your state, the state does not check to see if you are violating anybody else's trademarks. So keep that in mind, that filing with the state is not the same as doing a check to see if anyone else is using that name and whether you can use the name from a trademark perspective. That raises a related issue. Some states allow you to do a state trademark registration. Don't do it. Don't waste your time, because all state trademark law is preempted by federal trademark law. So you are wasting time and money to do a state trademark registration. There is virtually no benefit to it. Technically speaking, in certain scenarios, there might be a small benefit, but in all my clients over the years, I've not seen one of those scenarios come up where it makes sense to spend any money on a state trademark registration. So if you're going to do a trademark registration, do a federal trademark registration. So let's recap. A trademark is any sort of mark, including a business name, that associates that mark or that name with the source of goods or services, like the actual company behind it. So, as you might imagine, the company can have a different name from the brand name, and the mark doesn't need to directly tie, but by using a brand name or a trademark, the business is telling the public, you can associate this mark with our goods or services, our quality. If somebody's infringing your trademark rights, send a cease and desist letter, and if needed, sue. But you can't just ignore it, otherwise you may lose those trademark rights. If you accidentally infringe somebody else's trademark rights, usually just by stopping, you can get them to go away. But sometimes you might have to pay some money to cover that trademark infringement and avoid a lawsuit. Those are great examples when you should consult an attorney. Also, when doing a trademark registration, I'd recommend using a trademark attorney. If you don't know of one, I'm happy to refer you to one. There's some good ones that I've referred people to over the years. And keep in mind, you don't need to do a federal trademark registration right away. You can start out benefiting from the common law trademark rights that you get when you are operating in a significant way, county by county. So whatever county you are making sales in and advertising in, typically you're going to start acquiring trademark rights in that county, as long as nobody else is using a similar business name or similar mark. So now we've talked about copyrights designed to protect artists, trademarks designed to help the public and businesses know who is behind the mark or the brand or the business name, and make that connection between the brand, the mark if you will, and the source of the goods or services that hold that mark. Now let's talk about two other areas of intellectual property law. One is patents. Patent law allows you to design a method, a recipe, and other functional aspects of a scientific design or a scientific process or formula. Now, you have to use a patent attorney when you do this. Typically, it costs you over $20,000 over a 2-year period. And here's another really important thing to know. You need to speak with the attorney and file patent registration within 1 year of your first sale, or otherwise letting your patentable concept be known by anybody in the public. So anyone outside your company. So patents are the exception to the idea that you can't protect an idea. Patents are the way to protect an idea. Now that idea has to be novel and unique. It may not be never contemplated ever, but there are very strict rules on what sorts of concepts can be patented. The patent period of protection is a little over 20 years, so you only have that protection for that period of time. Also, you have to make public in your registration your recipe or secret methodology. You might say to yourself, well, what if I don't want to do that? What if I want to keep that confidential, but I still want to protect it? For example, let's say you came up with a recipe for Kentucky Fried Chicken, and that recipe was so good and customers love it, and you want to have that restaurant around for more than 25 years. So a patent around the recipe isn't enough. What can you do to protect that recipe? Keep it a secret. We call this area of law trade secrets. It's basically when businesses, those who are in trade, have secrets. There's a Federal Trade Secrets Act. There are many state Trade Secrets Acts. The laws basically say this: as long as you make reasonable efforts to keep something a secret that you use in your business, nobody else can use that idea. It can't be shared, it can't be stolen. Now they can independently come up with the idea, usually, whereas if it's patented, they cannot. So what's the takeaway here? Well, if you have some sort of secret recipe, formula, concept, or compilation, one option is just keep it a secret. You don't have to go get a patent. The other option is to go get a patent registration. And if you do that, keep in mind, you have to reach out to a patent attorney and file the initial patent application within 1 year, so less than a year of that idea being shared outside of your company. So that's the area of patents and trade secrets. They basically keep your ideas, concepts, formulas, recipes a secret, or at least, and that's in the case of trade secrets, or in the case of patents. So now you have many semesters of law school intellectual property courses boiled down into the essence, the essential things that you need to know as a business owner. So if you're creating something, you can protect it by copyright, and you can use a copyright registration and do that without an attorney. If you have a name or a brand that you want the public to associate with your goods or services, then you are acquiring trademark rights, and you can consider doing a trademark registration if you'd like. For that, you should use an attorney. For trade secrets, these are secret ideas, formulas, and recipes. The key there is just keep it a secret. Make reasonable efforts to keep that a secret. Maybe some of your employees need to know about it, but make sure they know it's confidential. Remind them in writing. Maybe on the recipe, it should say highly confidential, trade secret. There are many different ways you can try to keep this confidential and keep proof or evidence that you have done what you could to keep that secret confidential. And then if you have some sort of formula, recipe, concept, compilation, or functional software, those are examples where you should consider getting a patent. You'll have to publicly disclose this concept, but you'll get patent protection, so nobody else can use that particular way without violating your patent or with your permission. And if you give them permission, that's called a license. You've authorized them to do it, and usually they're paying for that right. So what's the next step? What do you do with this knowledge? Well, first I would think about, in your company, what intellectual property do you have to protect? And then second, make a plan for how are you going to protect that. Are you going to file a copyright registration yourself? Are you going to do a trademark registration with an attorney, or just rely on common law trademark rights? If you have a concept, will you just keep it secret and label it as secret and confidential? Or if you have a formula or concept or software, are you going to be working with a patent attorney to look at doing a patent registration? So go ahead and take some time. Make a note of the intellectual property you have, especially the intellectual property that's really valuable to you. And then make a note on your task list. What's the next step in order to make sure that intellectual property is protected so your competitors can't use it without your consent? Coming up next is the area of legal compliance. We're going to talk about a number of ways you can avoid problems with government authorities. Maybe it's the federal government, state government, or getting sued. Avoiding audits, investigations, attorney general lawsuits, and all sorts of other problems. Some of these might involve licenses, the right to do business in a state, or tax penalties and having to cover attorney's fees. This is a whole category of complying with the law so that you can avoid getting into trouble and being distracted by all the time and expense and legal fees, allowing you to instead divert your attention to the business you love, growing your company, serving your customers and clients, and creating a great company. I'll start out by talking with you about important filings and statements you send into the government. Next, I'll talk with you about how to avoid being personally liable for stuff that happens in your business and avoiding losing your house, your vehicle, or any other assets due to legal stuff that happens in your company. I'll talk about the important legal documents in your company so you can make sure you have those. And then we'll touch on exit planning. Every one of us will leave our company through death or prior to that. And so we'll talk about some of the options for planning that, some of the best practices, and the big mistakes to avoid that are fairly easy to avoid if you know how to do it. We'll talk about some of the big ways to avoid problems with employees, how to reduce taxes, and how some of your legal troubles can be mitigated by just getting a couple insurance policies that could be extremely valuable to you. Although we've talked about contracts and every business owner deals with those, and we've talked about intellectual property, how to protect yours, and how to avoid infringing other people's intellectual property rights, business owners often tell me this next section saves them the most money, reduces the most anxiety, and helps them feel the most empowered because we cover a lot of the legal problems that business owners accidentally face. And my hope is, with this next section, you won't make the mistakes that those business owners made.